My name is Michele Ferroni. I'm a criminal defense attorney. I have been in practice for 25 years. I started out my career as a public defender, and I've had my own practice since 1997. I've been asked what 3 tips I would provide to a medical marijuana patient that comes to my office. The first thing that I would advise them is to exercise their Fifth Amendment right to remain silent. If they haven't done so at the time of the arrest, I would advise them to do so from that point on, from the time that they see me. The reason being is that, first of all, the law mandates that the prosecution prove a case against a potential client, which means that my client doesn't have to say anything, that the prosecution has to prove all of the elements against them. The second tip that I would give a medical marijuana patient if they're detained by an officer is to realize that an affirmative defense is not necessarily immunity from arrest. I think that clients are very misled by that. They feel that when an officer stops them, they can pull out their medical marijuana card and that's going to bar them from arrest. The legislature envisioned that would be immunity from arrest, but unfortunately that is not the reality. The affirmative defense is a tool that is used in court. Typically, the elements of the offense are met, but the person has a defense to the allegations that will exonerate them by law. So it's really not until after a case is filed, whether it's the initial stages, before a preliminary hearing, before a trial, that a client has an opportunity to put on the defense, which would include the possession of the medical marijuana recommendation and to show that they were within the guidelines of the recommendation.